Good morning. Are you Travis Smith? And Mr. Smith was previously in court, entered a plea of guilty to theft of property with previous convictions. And I've received the pre-sentence report. Have you both had an opportunity to review that report?
I've read it, John.
I have, Judge.
Are there any additions or corrections?
No, well, one thing is it's an addition, and I just found out about it Friday. In the report, it says his mother abandoned him at 3, which is true. But she's now straightened herself out and she's helping run a rehab center in Lafayette, and it's going to become part of his life. He's got 2 uncles here. So he has, they're in the courtroom. He has strong family support.
Okay,
A lot stronger than what that says.
good. Thank you.
Uh,
I am also going to take judicial notice of the court's file. Mr. Smith was previously found not competent and was sent to the John Dunn Behavioral Science Center and restored competency. Any issues right now before sentencing with competency?
No, I think have you been taking your medicine in jail?
Okay.
I don't think so, Your Honor.
Okay,
But I'd have to be a psychiatrist to truthfully answer it,
Okay.
correctly answer it.
All right, so Mr. Smith, I'm going to find that you previously entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty, and at this time, follow the agreement that you made with the district attorney. Find you guilty of theft of property with previous convictions. Sentence you in accordance with that agreement to a term of 2 years in the state jail prison. But that will be probated for 5 years, so you'll be on probation for 5 years. You're ordered to pay the $1,000 fine and to follow all of the rules and conditions of probation. That is going to include being on the mental health caseload so that you can get whatever help you need. Follow all of those recommendations, meetings, medication, whatever. That's all part of your probation now. You do all of that. This is a great opportunity for you to get your life back on track. And you'll be able to serve that 2-year sentence while you're out on probation. The other side of that, though, is if you violate any condition of probation, you'll be brought back into court and you could be facing that 2-year sentence that you've agreed to. Do you understand?
Yeah.
I'm handing you 2 things. One is the trial court certification that shows this was an agreement that I followed, and so you waived your right to appeal. I've also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. If you have any questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Adams.
Judge's misdemeanor will be dismissed.
Yeah,
Okay,
that's what I was
thank you.
gonna say.
All right, so
You're
they'll
gonna-
get that misdemeanor dismissed as well as part of that this morning. Okay, good luck to you.
Thank you, Honor. He be released today.
He should be,
Yeah.
yeah, as long as there's no other hold that misdemeanor, once if there's nothing else in the other county. But if it's just this, yeah, you should be released today and you'll get some instructions today before you leave the courtroom from probation. To tell you exactly what to do when you're released, okay? Okay,
Thank you, Honor.
yes, sir. Ms. DeLage, you have Jeremy Alexander.
Yes, Your Honor.
Good morning.
Good morning. Rainy morning.
Yeah,
That was a lot of.
very rainy, a lot. Morning. Good morning, sir. You Jermaine Alexander? And this is 26 DCCR 0178. Mr. Alexander is charged with injury to a child, elderly or disabled individual. And what is the announcement?
Your Honor, we're gonna ask for some more time. I'm still waiting for some discovery. I have not gotten any of the videos yet. Did talk to Mr. Smith about that. We're thinking they might be online, but they weren't given to me yet, so I'm gonna double check.
Okay, so if y'all will both check on that. And so, Mr. Alexander, I'm going to reset your case so that Ms. DeLage can get all of the videos and everything that the state has. And she'll be able to be out there hopefully before that next court date to go over all of that with you, show you everything. And then we can get an announcement at the next court date. Okay, you go back with the bailiff.
Just. Thank you.
Thank you, ma'am. I could just put a notation. Videos. specifically, yeah. Brian McWade and Mr. Macon.
Good morning, Your Honor.
Good morning.
Sorry.
Yeah. Good morning, sir. You Brian McWade?
Yes, ma'am.
And this is cause number 26 DCCR 0402. Mr. McWade is charged with aggravated assault with a deadly weapon. Mr. Macon has filed a motion asking that I set a reasonable bond. What is the bond currently?
$500,000. It was time.
Were we here already on a bond?
That was the first motion I filed to try and lower the bond, and we denied it.
This is April.
Right. I
April
usually don't,
22nd.
I usually don't do this twice.
Oh, okay.
Unless something, significant has changed, if there's some new evidence, other than that, it's just a matter of if the case is gonna go to trial, then there can be a rejection and we can get it set as quickly as possible, but unless there's new evidence with regard to a bond, I'm not going to hear the same evidence again. The fact that he's still in custody isn't necessarily new evidence.
He has a job waiting for him with Utah, right? As an electrician.
Okay. Ms. Malfino,
Judge,
does the state have?
I apologize. This was formerly a 5A case, and I don't know if maybe it got piggybacked along rather quickly and it was not on our docket. If you could give me a few minutes, I'll either go get it. I would appreciate the opportunity to at least review it. Its court has already heard this. I'm sure my position will be the same as Mr. Coleman's originally was.
Yeah, and it shows on my docket that it's Mr. Nichols. Is that not correct?
It may be, Judge. I think it was an add-on. I didn't have it on my docket, didn't have it pulled for this morning. But we'll get it, Judge.
Okay, well, it's on the regular docket, so it wasn't added on too late, but maybe it was a week or so. Let me hold it for a minute. Just go back with the bailiff.
Some of that is the numbers changing in
Right.
the computer. They print out different numbers. Take a minute.
Mr. LeBlanc, looks like are you working on Derek Shinkle? Okay, I'll hold it. Mr. Rojas, you have Vicente Gloria? Hold on a second.
I'm gonna ask for a reset. I'm trying to run out some more information.
Okay, we're gonna reset Vicente, we'll reset Vicente Gloria. John Hill?
John Hill.
Good morning, good morning.
Good morning. Good morning, Your Honor.
Good morning, sir. Are you John Hill? And let me get this pulled up correctly. Mr. Rojas, will your client waive the formal reading of the motion?
He will, Your Honor.
Mr. Hill, in clause number 22-40932, I have an amended motion to revoke your unadjudicated probation. Shows that you were placed on probation March 28th of 2023 for the third-degree felony offense of forgery of a financial instrument. Is it a third? The docket for some reason has state jail beside it.
It looks like it's a third, Your Honor. On the motion, on the admin.
Okay. I just want to make sure I'm saying the right thing because it has SJ on the docket.
It was enhanced, Your Honor.
Okay, so it was a state jail felony forgery that was enhanced to a third degree,
Yes, Your Honor.
and it was a 5-year deferred probation. Is that correct? The motion alleges that you violated your probation. Count 1 alleges that you committed the offense of theft of property less between $100 and $750, April 15th of 2026. Is that true or not true? True or not true?
Judge, we can drop count 2. It's duplicative. It's injurious habit. We're committing theft. I'm sorry, we're gonna drop count 2 just because it's duplicative.
Count 3 alleges that you're behind in your court assessed fees. As of April 16th of 2026 in the amount of $10,859. Is that true or not true?
True.
Count 4 alleges that you failed to report as directed to the probation department for the months of April and May of 2026. And is that true or not true?
True.
Count 5 alleges that you failed to remain in Jefferson County, Texas, and that you were in Orange County, June 1st of 2026, where, without permission. Is that true or not true? True. And then count 6 alleges that you failed to immediately report the arrest for theft of property to your probation officer. And is that true or not true?
True.
Did you enter your pleas of true to counts 1, 3, 4, 5, and 6 freely and voluntarily?
Yes.
And did you plead true to those counts because they're actually true?
Yes.
Give me just a second. I need to look back at some things to understand. Looking for the PSI. Also.
Is your question about 3, Your Honor?
It's actually a third degree. It wasn't enhanced. It was not
Okay.
enhanced. It was a third degree forgery.
Then-
That was amended back when he entered that plea in March to show that it was just the caption that was incorrect. Okay. Got it.
I'm sure.
What is the status of the new theft case?
It's pending, Judge. When this is over, we're gonna take him down the hall and give him plea to that one as well.
I know.
I believe it's set this morning also.
I realize most of this history is very old. I just don't know that I love a 45-day sanction for someone with this kind of history for the same type of. I mean, it's a theft.
And Judge, if I can, the thing that he was stealing food, it's not like he was out stealing stuff to go, alcohol or anything like that. He and his son have started a trucking company. He is going to be gainfully employed when he's released. And I think, as far as I know, the court's not really concerned about the money, but he did have an accident which made it hard for him to stay up to date on probation fees. And he's trying to turn his life around, Judge. I think like I said, he started the trucking company. That's a step in the right direction, I think.
All right, so Mr. Hill, I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you sign these, did you go over them with Mr. Rojas?
Yes, ma'am.
Do you fully understand them? And do you understand if I follow the agreement that you've made with the district attorney that you'll be waiving or giving up any right to appeal?
Yes.
Now, it looks like the agreement is for me to continue you on probation, but order a 45-day sanction as a condition and with the, I guess, the caveat that you're going to go take care of the other case. There's going to actually be a plea. It's not getting dismissed, correct?
That's correct, Your Honor.
Is that your understanding?
Yes.
Obviously you can tell I don't love this agreement. I want to make sure you understand if I follow this agreement and you're in trouble and you're in here again on another motion, it's not going to go this way. Okay.
But I'm embarrassed.
All right, I'm going to, state tenders number one.
No objection.
It's admitted any evidence that Mr. Hill's not competent.
No, Your Honor.
All right, sir, I'm going to find that you entered your pleas of true to counts 1, 3, 4, 5, and 6 freely and voluntarily. Find those counts true, find sufficient evidence to find you guilty and revoke your probation, but I'm not going to do that. I'm going to continue you on probation. I'm going to order that 45-day sanction. And you will get, agreement is for him to get credit since the motion, right? The arrest on the motion.
Yes, Your Honor.
So you will get credit on that 45 days for any amount of time that you've been in since you were arrested on the motion to revoke. So not from the original part of the case, but just since you've been in on this. I'm going to hand you the trial court certification that shows this was an agreement that I followed, and so you have waived your right to appeal. Take advantage of this today. All right, good luck to you, sir.
Thank you, Your Honor.
You can go back with the bailiff.
Yes, ma'am.
Pedro Martinez. Yeah. Good morning, sir. Are you Pedro Martinez?
Yes.
And this is cause number 26 DCCR 1085. Mr. Martinez is charged with assault, family violence by impeding breath or circulation. Mr. Rojas, what is the announcement?
Judge, if I may, have a name called and document a few things for the court's record.
Sure.
The name of the complainant is Margaret Samano.
Margaret Samano.
Margaret Samano. Margaret Samano.
Judge, may the record reflect that the complainant, Ms. Samano, has not appeared in court today. We're not surprised by that. I did make every attempt to reach out to her, known information I had. I also asked my family violence investigator, Ms. Guidry, to reach out to her. It's apparent to us from one, she non-prosecuted, so to speak, in the offense material. And two, I don't believe she has a permanent residence, and they have attempted to track her at some known locations for people who don't have a stable place to reside, unable to do so. We did find one email to her at a Gmail account. We made every attempt to send notification there to please contact us both in English and in Spanish. She has yet to respond, Judge. Obviously, the nature of the offense is concerning with it being a family violence, but on the other hand, the fact that the defendant has been in custody, I feel with that information, it was my duty to, at this time, move to dismiss, and if further information comes to light, I will bring it to the court's attention.
Okay, then I'll sign that. Obviously, Mr. Martinez, I'm taking a look now at that probable cause affidavit. So something went on that night that shouldn't have gone on. And the fact that she isn't cooperating, makes me very concerned, but it is what it is. If you end up back in here, or if she changes her mind, they could re-indict your case, but whatever was going on you need to stay far, far away from that.
Yes.
All right, you can go back with the bailiff.
Thank you, Justin.
I'll sign it as soon as it comes through.
You tell.